Hello, everybody, and welcome to our monthly Lunch and Learns. Today, we are joined by Sarah Hedden from Center for Elder Law and Justice to talk to us a little bit about what to expect in family court as a kinship caregiver. My name is Rae Glaser. I am the director of the New York State Kinship Navigator program. I'm just going to give a couple of quick housekeeping updates and overview of the Navigator, and then turn it over to Sarah. So just to let everybody know, these Lunch and Learns are recorded. If you've registered, you will get a email within the next week or so with a recording link from this webinar, as well as Sarah's handout for today. Everybody is on mute, so Sarah and I are the only ones that will be able to speak. If you have questions during the presentation, feel free to drop them in the chat, and I will relay them to Sarah as we go. Once again, my name is Rae Glaser. I am the director of the New York State Kinship Navigator program. The Kinship Navigator and the KinCare Coalition sponsor these monthly Lunch and Learns. We are information, referral, and education for kinship caregivers across the state. I think everybody on the call is very well aware of what we do, but we take calls, emails, and we have a website as well for kinship caregivers and any type of caregiving arrangement, potential kinship caregivers, and professionals that are working with caregivers. Our helpline is open 10 to 4, Monday through Friday, and we have a website, www.nysnavigator.org. We are not an on-site service, but we work with caregivers to provide that information and referrals to agencies much like yours, for the folks that are on the call that provide those on-site services. And the Navigator has worked with Center for Elder Law and Justice. Oh my gosh, Sarah, what's it been? At least 15 years, I would say, if not more,
Yeah.
for caregivers that are in need of a little bit of legal assistance. Now, the Center for Elder Law and Justice covers 4 counties in Western New York: Erie, Niagara, Cattaraugus, and Chautauqua. But the Navigator works with Center for Elder Law and Justice to provide virtual consults for caregivers that are looking to get some help in preparing for family court, for legal custody, legal guardianship proceedings, adoption, and anything else that really happens in family court. So if you as a professional have a client that you think might benefit, feel free to drop us an email at navigator@nysnavigator.org. We do ask that you reach out to us first and don't have the client reach out to us first, simply so that we don't refer that client right back to you. And one of our kinship intake specialists will help you out with that referral if Center for Elder Law and Justice is able to take that. With that, I'm going to turn it over to Sarah to talk a little bit about what to expect in family court. Thanks for joining us, Sarah.
Thank you so much, Rae. This is my first time with Canva, so hopefully it goes smoothly. So bear with me. So for those of you who don't know CELJ, we've been providing civil legal services since 1978 and kinship care representation since about 2000. And I've been with CELJ since 2016. My 10-year anniversary is in March. I've been in the kinship unit my whole time here, and I've represented thousands of caregivers. Today, I'm going to give you a primer on what kinship caregivers can expect in family court. And my goal is to make the process a little easier to understand and navigate for caregivers on the call, for professionals to help give some information to caregivers. And as Rae said, I do welcome questions as I go through my presentation, and Rae is going to monitor the chat. I'm not sure if you guys can see this drop down in Zoom. I'm not sure how to make it go away. It might just be there for the whole time.
No, that's not. It's just you. So we're good. We can just see a slide.
Okay, good.
Well done.
Oh, thanks. It's hard because you don't, as the presenter, you don't know what you're seeing.
Totally get it.
So our mission is to improve the quality of life for older, disabled, and low-income adults through civil legal services, primarily in Western New York. We do have some programs that are available statewide, including our senior legal advice helpline. Our goal is to use the legal system to ensure that our clients may live independently and with dignity. A little bit about me. I have my Juris Doctorate and also my Master's in Social Work. Before I became an attorney, before I practiced as an attorney, I worked with Crisis Services in Niagara County. with CPS in Niagara County and as a social worker in therapeutic foster care in Erie, Niagara, Chautauqua, and Cattaraugus counties. So I've got quite a lot of experience on the social work side and a lot of experience on the legal side representing kinship caregivers. I've not represented parents or children, but I've worked with a lot of attorneys representing parents and a lot of AFCs. So I just wanted to give everyone a primer on all of the docket numbers that, and what a docket number looks like when you're in family court. So here are all of the iterations of docket numbers in family court. You've probably seen a lot of these. I imagine there's a few that you haven't seen, such as M, your marriage application. K, destitute child might come up a little bit here and there, but that one's pretty rare also. So if you look at the bottom here, this sample docket number, I'm going to use V since that is for custody and visitation of children. And that is mostly what we're going to focus on today. Sorry, trying to be fancy here and it's not working.
It's all right. You can
So
use us.
the letter at the very beginning is the type of case. So V for custody or visitation. If it was G, it would be guardianship. Some of you might see that one here and there. N is a really common one in our work for neglect. The next set of numbers is the petition number. I use a high number. Even in Erie County, they usually only get up to around 10,000 for petition numbers. So this shouldn't be a petition number that anyone could look up or is actually assigned to anything. Maybe in New York City. So the petition number is 5 digits. In the smaller counties and at the beginning of the year, they usually start with a lot of zeros. And then the last set of numbers, you'll typically only see 2 numbers, like right here, -26 for this year. This, when you see it looking like this means that this was a previous docket. So there's an order entered under this docket number ending with 23. And then somebody filed to modify in 2026. And A means this is the first petition that was filed in 2026. So maybe I have an order of custody for my children and somebody filed for visitation with my children. Maybe my mother filed and then I filed. So she's, sorry, let me speak again on that. So let's say I have an order of custody for my children. My children's father files to modify that order, so it's given an A. I then file to modify and it's given a B. They're on I have seen some going to double letters, which is pretty wild, but doesn't happen a lot.
Sarah, we do have a question coming in. This may be something that you address later on, but we have a caregiver that is a legal guardian of her grandchildren, and she's wondering what the advantage is of adopting her grandchildren.
Sure, I will, if I could hold off on that question, I do get into
Sure.
guardianship and adoption a little more extensively later on. I might not address your question specifically, and you could always reach out to Rae and ask for a consultation with us, but I will get into that a little bit more later on. More generally, the benefits of adoption, mostly through foster care. And I also want to mention, I don't have it on here, but each family also is assigned a file number. So in larger counties, for example, Erie County, there are 5-digit file number. Smaller counties, such as Cattaraugus, there are 4-digit file number because they haven't had over 10,000 cases yet. They're usually linked with the father if there's a custody or neglect file. If it's a new filing, such as a family fence petition, we have a elder abuse unit, so we might have a client of ours file against their adult child. It's just the 2 of those adults. There's no father involved, so that would be given a new unique file number. And at the end of my presentation, I'll give you a tip on what you can do with that file number. I also want to mention that when we're talking about these visitation and custody matters, you'll often hear them referred to as the docket, such as, and these neglect and abuse matters are referred to as N dockets, that's because they start with that letter. These custody matters, V dockets, are also sometimes referred to as Article 6 matters. All matters in family court are governed by the Family Court Act, and Article 6 of that act, it has 10 acts total. Article 6 of that act governs custody and visitation matters. So you might hear in that a custody or visitation matter referred to as a V docket matter, or a neglect matter as an N docket matter. You also might hear the custodian referred to as a V docket custodian or an N docket custodian, particularly in such as like Niagara County. They refer to caregivers under those neglect dockets as N docket custodians. They could also be referred to as 1017s. 1017, 1017 is the section of Article 10 of Family Court Act that governs the placement of children under neglect. So that's where that term comes from. Any questions yet, Rae, before I go on to the next slide?
Nothing here.
Okay, awesome. So how does a custody matter begin in family court? A lot of matters, as Rae and I see, and you might have seen in our families, they begin with a safety plan. Some start with their safety plan and start in family court, some progress to family court. Sometimes they can start with or without CPS involvement, but regardless, a lot of caregivers find themselves in family court. Typically, the caregiver is aware there's an issue. They intervene. They might take the kids into their home. They might contact CPS, and that could lead to them taking the kids into their home with or without that CPS involvement, making a safety plan. Or they might intervene by filing a petition in family court, again, with or without CPS involvement. Many grandparents care for kids without ever going to court and having the explicit authority to care for them. In some cases, the parent and child live with the grandparent. And I'm sorry, I'll stop myself for just a moment. I'm going to say grandparent and grandmother a lot. I believe, Rae, correct me if I'm wrong, about 65% of kinship caregivers are maternal grandparents.
Yeah, and that's what we always default to when we're speaking. And, the preface is that I'm sure you're going with this is that it can be any kinship caregiver, but since we see the maternal grandparents the most often, that's what we're defaulting to.
Absolutely. Thank you. And I don't mean that to discount other relatives or fictive kin. It's just the easiest to say grandma and grandparent.
Yep.
Thank you. So in some cases, and I'll also say mom and dad. It's easiest. So some cases, mom and kids live with grandma. Mom attends those appointments and consents. Often I see that the provider is familiar with grandma and allows grandma to consent even when mom isn't there. Sometimes it doesn't work in a bigger city, or when the child needs new care, such as they need to go to a new provider for a new assessment, maybe for a new diagnosis or some teeth issues is something that we often see in dental work. So in that case, grandma now needs authority to act on behalf of the child if the parent is unable, unwilling to consent, or just not present. In that event, grandma needs to file a petition asking for an order of custody, allowing her to make medical and educational decisions. We'll talk shortly about what you need to plead on your petition, and when I say plead, I mean what to write on your petition. Any questions on this slide before I move on?
No, this is great, Sarah. Thank you so much.
Thanks. So before I get too much into your petition, I want to talk about what custody is. So legal custody refers to who makes decisions. As I had talked about, grandma sometimes won't be able to make medical, educational decisions because she doesn't have custody. Parents, when they have a child, they are the de facto custodian. They automatically have custody without ever having to go to court. And a lot of parents and families never go to court. They just raise their children without any court involvement and without any court orders. So Legal custody is who makes those major decisions for the child. And there's almost always a preference for parents to be involved. I'll say almost always a lot because there's usually no absolutes. And sometimes there could be really egregious circumstances in a case where the parent should no longer be involved or there's an order of protection until the child reaches adulthood. Um, but that's not true in most cases, almost all cases. So even when grandma is given sole custody, where she's the sole person making decisions for the child, she should still be informing the parents of appointments and important events, even if she's not ordered to do so. It's best for the family, for the child, and it's going to help in the future if she ever does need to go back to court. I'm sorry, my dog is barking in the background.
He's actually very quiet. I had to lock my cat out, and this is just what happens when we work from home. I think most people on this call today have got a lot of snow happening.
We do here too.
Yes.
So we talked about legal custody. Residential custody refers to where the child lives. So let's say mom and grandma have joint custody and grandma is the residential custodian. The providers will usually let grandma make unilateral decisions on behalf of the child if grandma's not available. So there is, and when I say that, there's like legal and what the law says, and then there's providers and what happens in the real world. So technically and legally, if there's joint custody, mom and grandma have to make those decisions together. Some providers will let grandma make those decisions if mom is not available or not present. Visitation is often, it can be as agreed and arranged or on a schedule. It is often as agreed and arranged, and it's important for caregivers to keep a note of when the parents visit and when they don't visit and why not. In the moment, on Saturday, when kiddo's excited to go and mom doesn't show up, it's really impactful to you and the child. And you might not think of this, but 6 months from now, you won't remember when that happened or exactly what happened and how. So it's really important to write those things down so that you remember. So let's get into the slide a little bit. Now that we know what custody is and you need custody because you've got a kiddo you have to make some decisions for, who do you need to file against and where do you need to file? What are those local customs? So I will often talk about Erie and Niagara counties because those are the two counties I've practiced in for 10 years, and they're very different with some of their local customs. So for example, in Erie County, you file a petition against mom and then a separate petition against dad for the child. So let's say mom has two children with dad number one and then one child with dad number two. You're looking at filing 4 separate petitions. So first 2 kids against mom, those first 2 kids against dad, and another petition, third petition, that third child against mom, and fourth petition, that fourth child against dad. It's a lot of petitions. In Niagara County, it would only be 2 because you're putting both parents on the petition for those 2 kids and both parents on the petition for the one child. You'll probably argue like, what the heck is she saying? She's lost me. I get it. But the big takeaway is check with this jurisdiction on what you need to file. Family court errs on the side of accepting petitions, and I do include a link at the end of my slide to the petitions that are provided by the court system. So if you or the caregiver files a petition and it isn't really in line with local customs, it's not a big deal. They will take it. If you are to put too many people on one petition, that could be rejected. But the clerks are super nice. And if you're nice to them, they'll be nice to you and they'll tell you what you need to do. So you've got your petitions prepared, they're filed, you go to court, nobody shows up. That happens pretty often. Now the parents need to be served with the petition. What does that mean? They have to be physically presented with the petition. The person that can serve them cannot be related to the case. They can't be a party to the case. So if it's mom and grandma on the case, grandma filed against mom, grandma cannot serve mom with that petition, but grandpa can. Grandma's other daughter can. Grandma's best friend can. Anyone can, as long as it's not grandma. and that person is at least 18 years old. It's important to know that you cannot serve anyone on Sunday or a holiday. If you do that, it won't be effective. It will not be valid service. There's also a common misconception that the person has to accept the petition or the papers. They don't. A lot of people understandably get upset when they're being confronted and given something and they don't know what it is and they're surprised. And as long as you just say, I have these papers for you, I'm going to leave them here. It's okay to set them on a table nearby or on the ground in front of them if they're refusing to take them. So let's skip back here a little bit, back to the petition.
Just a
So
quick
in the,
question coming
yeah,
in,
go,
Sarah.
please.
I have somebody asking, is custody the same as guardianship? And I can answer that as non-lawyer and link our fact sheet. But I'm wondering if the question really pertains to, does it matter what you're filing for in terms of the process? Like, is the process for custody versus guardianship any different? And as a non-attorney, I will say there are some key differences between custody and guardianship. We absolutely have a fact sheet on that that we can help you out with.
Yep, yep. And I do get into that a little bit, the difference between custody and guardianship. So I'll put that question off a little bit. That's okay. And Rae, when I get to that point, if you want to jump into, it's interesting. There are less differences now between custody and guardianship. So I'll pique your interest with that and keep you hanging on for a little bit longer. And I will say that recently, in both counties that I practice primarily in, we're seeing more filings of guardianship in family court. So guardianship is almost always filed in surrogate's court,
Okay.
but it's been filed more in family court, and I can't quite figure out why. I've asked a lot of people. I don't know. Guardianship is typically needed when the parents aren't available, usually due to the parents are deceased. So there's no one to file against. But I'm seeing guardianship petitions in family court where the parents are still living. So there's no need for guardianship petition. But we'll get into that a little bit more. I'm saying speak out of time here. We'll get to that. I just want to talk a little bit more about um, the custody petition. So guardianship is a little different, where in guardianship petitions, you're really just alleging why the parents are not available and why you're the best guardian for this child. In custody petitions, you need to plead extraordinary circumstances. I'm sure everyone, because you're here, you've probably heard that term before. That term first came about in 1976 by the Court of Appeals. That's the highest court in New York State. It's a little confusing. In New York, our lowest state trial court is Supreme Court, and our highest court is the Court of Appeals. So in 1976, they issued a decision, Bennett v. Jeffries, and that defined extraordinary circumstances. In short, extraordinary circumstances are when a parent surrenders the child, they've abandoned the child, there is persisting neglect, unfitness, or other like extraordinary circumstances. That general term for the last 50 years, now it's 26, so 50 years old, has been defined further in thousands, if not tens of thousands of decisions. So you can find a ton of decisions on what is extraordinary circumstances and what is not.
Mm-hmm.
After you plead what the extraordinary circumstances are, whether it's parental untreated and unmanaged drug use, untreated, unmanaged mental health issues, serious and damaging to the child domestic violence, homelessness, you then need to allege the best interest, that it's in the best interest of this child to be with grandma. So you want to talk about your ability to care for the child, your prior relationship with the child and involvement in their life. Some information about your housing. Do you rent or own your home, and how long have you lived there? Your income, the source of it. Do you work, and is it sufficient to provide for the child? Your mental health. It's okay to have mental health diagnoses so long as they're adequately treated and you're either currently in treatment or have been successfully discharged. And same with the substance use disorders. Do you have criminal history and CPS history? If you do, it's my opinion as an attorney, it's best to put these things out there. Same with mental health, substance use, anything that can be looked on and used against you. Own that right up front and say, I have this in my history, and here's how I have rehabilitated myself since then, and why, despite that history, I am still the best person for this child. And very importantly, your willingness to facilitate a relationship with the parent, with both parents, and with the sibling. It's often that maternal family might not be as close with father and paternal family and vice versa. It's important for children to have a relationship with both sides of their family. And the more loving adults that are in the child's life, the better. So it's best for a grandparent, a non-parent who's petitioning for custody to prove how they're going to facilitate those relationships.
Question, Sarah. If somebody is homeless and you don't know where they are there ways to serve them? Is email ever an acceptable format?
It is pursuant to court order. So it's a little more difficult in family court. So you always have to try to serve somebody personally. So you have to have at least an attempt. And usually we will have the sheriffs go because as attorneys, we can certify our clients as poor persons and ask the sheriffs to serve folks without cost to our clients or the firm. So we will have the sheriff's attempt service or a process server. Or if you're doing this on your own, you can have a friend or family member or process server try for you and try at their last known address. And it's best to make at least 3 attempts on 3 different days. If you can't, if they've not been able to be located and you do have a different way to get in touch with them, whether it's a Facebook account, a cell phone where you can text them, an email address, you can then file a second filing with the court, a motion, asking the court to issue an order allowing you to serve that parent by substituted means, either through a text message, through an email, through a Facebook message. And very often the AFC, the attorney for the child, is typically in favor of that child being with the grandparent. And that's because maybe even if the grandparent isn't perfect, that's the person who's here loving the child, caring for them, and asking to care for them. That AFC has met with the child, they've seen that relationship and bond, and they're here to help resolve this case and move it along. It's not their job. They represent that child, but it's in their client's interest to help get this case resolved and finalize it with custody. All that said, the child's attorney will often give some advice and tips and maybe even draft a motion for the caregiver to get service done by different. There are any other questions before I move on?
Looks good from here.
I'm looking at my notes, and that's actually what I was about to get into was substituted service. There's one other way, which is mail and mail at their last known address, which mail and mail or publication. Mail and mail means you take a process server takes the petition, they affix it to the door. They don't actually nail it to the door, just like tape or something, or stick it in the screen door, and then also mail a copy. If somebody new is residing there, they might get it to the person that's not as likely to notice the parent, that there's a court case pending. Publication, I think, is the least effective way to notice somebody that there is a court case pending. Not a lot of people read those. So back to my presentation. So when you're filing a petition, there's 2 different petitions you can file. One, you can just file the petition and wait for your court date. You might get it in 2, 4, 6, 8 weeks. It depends on the jurisdiction, the time of year, what's happening in the world. When courts were really delayed because of the pandemic shutdown, there was months delay between filing and a petition being heard. But sometimes there's an emergency and that caregiver needs to get custody of the child right away. maybe something is happening with the parent and it's unsafe and that caregiver needs custody right now, or the child needs a medical procedure. It's really important and they can't get it without grandma having the authority to consent to that procedure. In that case, if it's more time sensitive, you can file what's called an order to show cause. They have those available at court and online at the email address I have at the end of my presentation. So with those, you still draft your petition just like you would as usual, but you attach an order to it. And the order says what you're asking the court to order, that until, and this is ex parte, which means the other party is not in court, and the caregiver is asking, even though the other parent isn't here, even though they don't know that this is happening, it's so important that I have custody right now that judge, I need you to sign this order and then bring this case back as soon as possible. I will share that some jurisdictions are in almost all cases not signing orders to show cause when a non-parent, a kinship caregiver, is filed and the parent is not in court and is not consenting. Because in those cases, the general belief is that CPS really should be involved. So orders to show cause are mostly not being signed. Again, I can't speak for every case, and this is just what I've seen in my experience lately. Excuse me for a moment. So you've got your petition filed, maybe a temporary order was issued, maybe one wasn't, and the litigation process carries on. So parents are typically assigned an attorney. They most often qualify for assigned counsel. And as you know, kinship caregivers don't qualify for assigned counsel as they're not one of the parties pursuant to the Family Court Act or the state constitution that is guaranteed counsel in these proceedings. That's why my program exists, and we are able to provide representation to some caregivers in some jurisdictions. But the majority of kinship caregivers are going through this without an attorney if they can't afford one, which is why I'm here today, and hopefully you're getting something out of this. So you continue through the process. The parents have attorneys. The child has an attorney. Grandma maybe has or does not have an attorney. You have your first appearance. The attorneys are assigned, and you continue through that litigation process. Sometimes it's rather quick. So in a case where maybe mom has had a pretty serious medical event, she's in the hospital for some time, and she agrees and she wants kids to stay with her mom. And maybe dad agrees or dad's not around or not available. They go to court, have a few appearances, and they're done. Sometimes there's a huge fight. Maybe there's some mental health issues that are unresolved for mom and she won't consent for some time. Or maybe grandma overreacted and she filed too soon and mom won't consent because kids should be with mom. There's a lot of reasons why these take a long time. Sometimes there's a massive court backlog, like during the pandemic, like I mentioned, and they can take a long, long time. Mediation is always an option, and I recommend almost all of my clients to participate in mediation, so long as there are no domestic violence issues. It's a great time for people to, most importantly, resolve their case, but to really, I guess I want to say air their grievances, but not really, just really connect and talk about what brought us here and how can we reconnect as a family. When families go through litigation and they enter the court process, it is damaging. Families almost never come out of litigation and family court better, and it takes some time to heal from this. Once attorneys are involved, they're talking less, they're saying awful things, and maybe these awful things are true, but regardless, it damages families and they need to heal. Going through that mediation process can really help them start the healing process sooner, can help resolve cases sooner, can help the families craft an order that works for them, that they had ownership over, rather than going to a hearing and the judge issuing an order that is just up to that judge and maybe doesn't work for the family, but they have to abide by it. Litigation can be scary. Trials can be scary. I will say that the vast majority of my cases settle short of a hearing. I did just finish a hearing, and I think it's like the fourth hearing in since the pandemic that I've actually completed and will get a decision on. So four that I can think of in 5 years as a full-time litigator. So that gives you some indication. The vast majority of these cases do settle.
A couple of questions coming in here,
Yeah,
Sarah. The first one is, can kinship care be temporary or short-term while the parent completes support programs or treatments? How complex is that process, slash likely that the parent will be able to retain reunification after kinship custody is granted?
Um, so let me break that down a little bit. So I guess the likelihood it's the families have almost total control over this if there's agreement. So in the case like you've mentioned here, so we want it temporary. Something happened, mom's not doing well right now, and she needs grandma to step in and take care of these kids. And maybe it's only going to be 6 months. Maybe mom needs to go to an out-of-state treatment for something. She's going to come home and do better, and the plan is for her to get the kids back. Let's say in order to do that, grandma does need an order. She goes to court, the family agrees. If it's that short of a time period, maybe 6 months, the case could stay pending in family court and keep the order temporary. And grandma could withdraw when mom is home and doing better and it's no longer needed. If it's going to be a little bit longer than that, and courts do have their standards and goals, and they don't want these cases or any cases lingering and pending indefinitely. So let's say it's going to be 6, 9, 12 months. And a final order could be issued. And again, I would highly recommend doing your best to have family input and control over the order. And you can include in the order some things that mom has to do in order to have the kids returned. And that's not that mom has to do them, but it kind of puts like a roadmap. So let's say maybe we want to see mom engage in mental health treatment and engage for at least 6 months or until successfully discharged. We want to see mom obtain adequate and suitable housing for her and her children. So you can include those things in the order. When you're ready to go back to court, you had asked what is the likelihood that this temporary order would be undone. I would say 100% if that's what the family wants. So if mom says, yep, my daughter's doing great now and she should have her kids back, and mom is like, yep, I'm ready, let's get the kids back, it's going to be undone. There will be a new order so long as that is what the family wants. Did I miss any questions in there? It was kind of a long question. I'm
I
sorry.
think that was very comprehensive, Sarah. We do have another one coming in that is a separate question. If the parent is in the armed services, might that affect the signing of the order to show cause?
It could. It certainly could. I've not had that case, so I'm sorry that I can't speak to it, but it certainly could affect it.
Okay. All right, we're caught up now. Thank you.
Okay, thanks. I'm going to move on and talk about neglect matters. And if there is anything on custody, we're going to talk about custody a little bit through neglect, but anything, please feel free to go back and ask some questions. So I want to kind of jump gears a little bit though and talk about neglect matters. When I say neglect, I mean neglect and or abuse. Abuse petitions are filed a lot less frequently than neglect petitions, so I am going to just say neglect. So how they progress through court. So before the petition is filed or when it's filed but before it's heard, the CPS worker is in contact with the family. They may be making some plans with the caregiver to take the kids. A caregiver does often take the kids before court. Sometimes it's referred to as a safety plan. Sometimes it stays the safety plan and a neglect petition is never filed. But we're going to talk about when they are filed. They are usually heard within 24 to 72 hours, depending on the petition. The parents typically appear in court, and there's usually an order issued where the children are placed outside of the care of the parents. And so I want to talk a little bit about order of placement of preference. So no matter how amazing grandma is, no matter whether she took kid every weekend, um, and when dad was minimally involved, if dad is appropriate and he's not a respondent, the child will get released to dad. But dad might have to consent to supervision by the department. The court may order that. Grandparents, so dad's first, non-respondent parent, mom or dad, whoever the non-respondent parent is, even if they were minimally involved. Next below non-respondent parent is grandparent. They're a spot above other relatives. And I highly recommend that maternal and paternal don't fight. You're certainly going to be different. You didn't meet each other. You didn't pick each other. Your kids did, but no infighting. Everyone is here for the best for these kids. Especially if there is, maybe a couple of sets of paternal grandparents and these kids are split up, then there certainly needs to be the adulting to really get along. And I'm sure a lot of the professionals on the call here really espouse the same advice. When kids are removed, they're often placed in foster care with non-relatives for a short period of time if the caseworker didn't have much time to investigate the family before the filing. But caseworkers certainly don't like to move kids more often than they have to. Every move is a new trauma. So ideally, if children have to be removed, they're placed with the family where they're going to stay until they're back with their parents. That's sometimes when my firm gets involved. If kids are removed and placed as foster parents with non-relatives, with folks they didn't have a relationship with before removal, that's often when we get involved to help the appropriate relative receive placement of the children, reduce that ongoing trauma. So after grandparents are other relatives, including fictive kin, so, teachers, friends of the family, and then after that is non-relative foster care. And that would include residential placements. So that is the absolute last placement option, is with non-relative foster care. So if a caseworker were to tell grandma, you've got to take these kids as part of the safety plan, or else they're going to foster care, it's almost always a threat, because caseworker already says grandma is appropriate. That's where they're going to go. So at that first appearance, mom and dad are given attorneys if they have not already been assigned attorneys. From there, some jurisdictions are having an appearance shortly after, where all the attorneys and the parties, everyone gets together with the judge's clerk, and they talk about what needs to happen. What are the next steps to get these kids back home? What led to removal, and what needs to be mitigated so the kids are safe to be back with their family. From then, some jurisdictions are doing those, some aren't. Regardless, that will be talked about, whether it's with everybody all together or not. From there, parents are ideally working on those issues while the court process is ongoing, and eventually it will be resolved, whether that's through the parent making either an admission, yes, I was homeless and didn't have appropriate housing for my child on the day the petition was filed, or they'll consent to a finding of neglect without making a specific admission. Yes, I agree that you could prove that I neglected my child, but I'm not going to admit to any specific action that I did or anything I failed to do. Or the parent does not agree, has a hearing, and the judge issues a decision, which is either finding neglect or not finding neglect. After that hearing, the fact-finding hearing. So there's two portions. If you think of it kind of like a criminal matter, which more of us are familiar with, I think from mostly TV. So the fact-finding matter is like the trial. Did he do it? And then the sentencing is like the disposition. So how long is this criminal going to jail for? I don't want to, now that I'm saying it, I don't want you to think that I'm referring to parents as criminals, just to liken the court systems. So similar to the sentencing phase of a criminal trial is the disposition phase. The disposition phase of these neglect matters is to, again, help the parent rehabilitate themselves and their family so that the kids can be reunited with them. It'll be a plan for exactly what they have to do. It could include mental health treatment, substance use treatment, domestic violence treatment, anger management, parenting. They need to obtain housing, income, maybe do a forensic mental health evaluation. Could be a lot of things in that disposition. And finally, permanency. And permanency is something that we talked about the entire time, really from day one. So the day children are removed from their parents, they don't have permanency. These kids are just, where do we go from here? They can't remain wherever they are on this temporary basis. Kids need permanency. And there's a few different options. They could be returned to their parent, which is almost always the first goal. And there's typically early on in the case some concurrent planning going on, where if they can't be returned to their parent, what is the other option going to be? That could be custody or guardianship to a kinship caregiver. It could be adoption. It could be another planned permanent living arrangement. Apple is a difficult one. So return to parent.
Anybody have any questions at this point in time? I was just going to give you a second to take a breath, Sarah. You've been doing so well with this.
Thanks.
I really like this graphic. It's very clear, very organized.
Oh, thank you. I worked hard on it. My first
Yeah,
Canva.
did a good job. You got about 10 more minutes, I would say, before we wrap up with last minute questions. So just kind of giving you a time check as well.
Okay, perfect. It should take me about that long to go through. Let me just see what my last slide is.
Perfect.
Oh, my final thoughts. Okay. So I just want to run through the permanency options for children. So when kids are placed outside of the home pursuant to a neglect, the first permanency option is almost always return to parent. And I know I say almost always because there could be a case where something maybe really egregious happened. I know, like, if the parent caused the death of a sibling, then return to parent might not be an option. There could be plan. The name of the order is escaping me. That and a no reasonable efforts finding. The judge finds that DSS does not have to make reasonable efforts to return to that parent. So that's why I keep saying almost always. So return to parent is almost always the number one goal. And that doesn't mean return always mean return to parent where the child was removed from. It could mean return to the parent, the other parent. Maybe that parent who wasn't quite as involved, but is now more involved. DSS will work with both parents and will return the child to whichever parent is ready first, because impermanency is itself damaging to children. While this is going on, it's often that parents feel DSS isn't acting quick enough and I'm ready for my kids back. Either parent at any point can file a motion under the Family Court Act, Section 1028, requesting that child be returned to them. And DSS then has the burden to prove that would be unsafe, or they could return the child. The second option is custody or guardianship to a kinship caregiver. I'm going to focus more on custody. We discussed this at length earlier, and that VDocket or custody petition always takes a backseat to the neglect. There has to be a resolution on the neglect before the custody can be resolved. It could take well over a year before even discussing the custody matter. It's particularly frustrating when the placement is foster care and grandma isn't even allowed to visit for whatever reason. And unfortunately, that happens in a not insignificant number of cases. I want to talk about adoption and guardianship together because I'm going to refer to guardianship in more of the kinship guardianship arena. And in order to adopt or take guardianship with a kinship subsidy while from a child in foster care, or with a child who is in foster care, that caregiver has to have been certified as a foster parent first. So the whether there's adoption or guardianship with a subsidy, that caregiver will receive a pretty significant stipend. However, guardianship is more akin to subsidy on the legal side as far as who makes decisions and that the parent retains their parental rights. So kinship guardianship, or as it's known colloquially, or guardianship with a kinship subsidy, really toes both lines. And sorry, I just want to scroll back a little bit in my notes. The differences between guardianship and custody. Rae, I know you had a little bit in here. Do you want to jump in while I'm looking for my notes on
Yeah,
that?
sure. That's okay. So the difference is, in terms of legal guardianship and legal custody, they're very minor, but we do have a fact sheet on it at the Navigator, and I'll drop it just in the chat for everyone to take a look at. It really has to do more with background checks and a couple of non-legal terminology, I guess, if you will. Usually guardianship is more so thought of as a little bit of a stronger designation for a family. But I will say that in looking at practice, the differences between the two are just so few. And I don't see a lot of families that opt to go for legal custody being denied things that legal guardianship families would.
Yep. From the legal standpoint, when I'm doing a consultation with families who are deciding whether they need custody or guardianship of a child who is not their own child, it's almost always custody.
Yeah,
The difference with guardianship, a caregiver would have to file for guardianship if the parents are both deceased,
deceased.
or if
Yeah.
mom is deceased and paternity was never established because there is no one to file against, or if the child has property or is expected to receive property, such as through an accident settlement or a wrongful death suit. So children or legal infants cannot own property. So another adult would have to be named as the guardian of their property pursuant to the surrogate court order of guardianship in order for that child to receive that property.
Okay. And if there's a question in the distinction, Sarah, I would think that that would be the perfect candidate for the navigator to refer to you, just to make sure that they're going through the correct course of action. We do have a couple questions coming in. The first one is, if permanency is granted to the kinship family while the parent completes treatment, will the parental rights be terminated or can they petition the court again later?
They can petition the court again later. So once an order of guardianship is issued on that petition for kinship guardianship with a subsidy, once that's final, there is no avenue then for DSS to terminate the parental rights. They're then intact. There would need to be a new neglect, a new parental termination of parental rights proceeding initiated.
Okay. Yep, that makes sense. And then the second one that came in is, what about kinship foster care and kin gap? I believe you've answered that question since it came in. Kari, if you need a follow-up, just let us know in the chat. And then the third one, is it accurate with custody? Oh, hang on. We had a very long question just come in from Heidi, so I want to take a look at the one right above that. Sarah, for post chats after this webinar, is this something that you would prefer people go through the navigator, or would you rather them email you directly? Just because I'm
If
looking at our time.
Yeah, I would say if they're general questions more from professionals, a quick email would be fine. If
Okay.
it's a question about a specific case from a professional or a caregiver asking about their specific case, if they could go through the process for a consultation, then we could speak with them more in depth about their case.
Yeah, that makes sense. Okay, so these two questions I've got right now. Is it accurate with custody, the caregiver wouldn't have automatic rights and consent would still be needed for things like medical care, education, decisions, etc.?
If the caregiver has custody, then the caregiver can give those consents. Nothing additional is needed. If the caregiver has joint custody with another person, such as the parent, then should be making those decisions together.
Okay.
However, like I mentioned earlier, if the caregiver is also designated the residential custodian primarily, a lot of providers will allow them to make that decision unilaterally.
Okay. Heidi, I'm going to ask you to send your email to the navigator because it's a pretty specific case question so that we can take a look at that. And then I can send it along to Sarah. And then Loretta, if you're interested in a consult, if you're working with a kinship support program, connect with your caseworker on that. If you're currently not, go ahead and reach out to the navigator directly and we'll get some more information about your case. All right,
Great.
Sarah, you got a couple minutes left.
Excellent. Well, perfect. Just one last slide on my tips, my final thoughts. Always go to every court appearance. It's really important to show that you're there. It can be a pain in the butt. On a day like today, when schools are closed, it snowed, but courts are open, it sucks. Still go. Especially if, well, I won't say especially, just go, be there. If you have a reason why you can't be there, something important, work and you can't get off, a doctor's appointment that can't be rescheduled, make sure you tell the court or let somebody, a caseworker or the AFC know. When you're at court, be quiet. It's so hard when you hear something that might be inaccurate, you want to jump up and say something like, no, that's not right. What you have to say will never be heard by the judge in the way you want them to hear it. All the judge is going to see is somebody who just can't keep still and is upset and speaking out of turn. So keep it to yourself. Take some notes, bring a notebook with you and write those things down. Really maintain, be careful of your facial expressions. I know one judge in Niagara County who is constantly catching people. She'll surprise me and call out other attorneys. Like I'll be taking notes and she's like, Miss Hedden. I'm like, it's just my face. Like I'm not thinking anything or doing anything. So just be aware of the expressions that you're making when other people are talking or the judge is talking and making a decision. Um, Really importantly, get involved right away. What I mean, so in a case where a child is taken by CPS, placed in foster care, I've had a lot of clients who come to me too late and they say, my question is, why did you wait 18 months? Why are you coming to me now? This kid was removed a year and a half ago. They say, well, mom told me that, things are going great and she's going to get this kid back. Don't take the word for it. Maybe she's right. Maybe that's what's going to happen. And maybe on day one, that is the plan and what was going to happen. Then maybe something else happened. I had one where grandma didn't take the child. And when the child was almost 12 months old, and she didn't take him because she took an older child. And she thought, this time I can't do it again. I need my daughter to not rely on me. I can't enable her by taking another child of hers. And it was working. Mom was doing great. Mom unfortunately passed away when the child was almost a year old. The child was then over a year old with foster family for over a year, and they had preferential standing. So it's really important to get involved right away. And by getting involved, under my third tip, it doesn't mean that you have to take placement of a child. I have so many clients, like I'm 44. I have a lot of clients in their 70s and 80s caring for young children under 5 years old. At 44, I don't know if I take a child who's under 5. Um, you don't have to take children if you can't, if you don't have the space in your home, if you're medically not well enough to care for a child for whatever reason. But you can be a visitation resource, visit with the child, offer to supervise visits between the parent and the child, offer to transport the child or the parent. You can help out in a lot of ways. Quick one, just be really nice to everybody, especially me and Rae. No, I'm kidding.
No, I like that. That's good.
Be especially nice to the caseworkers and the court staff. They have really hard jobs. The caseworkers are not perfect and they will say the wrong things and they will use the wrong tone, but you don't know where they just came from. So just give them grace and be nice to everybody. And I just want to give you 2 useful websites. I'm not sure how to click on them and I don't want to take up too much time. The top one is quickly, the bottom one will take you to the court website where all of the sample petitions are listed. The top one is Web Family. If you go to that website, you can put in the county and then the file number or the docket number, and it will tell you when the next court appearance is, how it is, if it's virtual, if it's in person, and who the attorneys are. So you can find a lot of useful information if you have the file number or the docket number. Okay, that's all I have with a few minutes to spare.
That was absolutely perfect. Sarah, thank you so much for your presentation today. We really appreciate it. If anybody has any follow-up questions, if they're regarding a very specific case, feel free to email the navigator, or if you're looking for a consult or you have a question about the consult, feel free to email the navigator directly, and we'll make sure that we put you in touch for Center for Elder Law and Justice. And then this presentation and recording of today's webinar will be sent to everybody in about a week that registered for the Lunch and Learn. And then this is just a plug for our next Lunch and Learn. It is Thursday, February 25th. We're working around the school vacation calendar, and we're going to have a presentation from Schuyler Center on their 2026 policy agenda, which will dovetail very nicely with where the KinCare Coalition is going. And stay tuned for tidbits coming out about the coalition's next meeting and policy agenda. Thank you so much, everybody. Have a great day.